And I know the court is aware, but for the record, the defendant was first placed on conditions in October 2021. He tested positive for THC, cocaine, and amphetamines. 2 tests positive for all 3 of those substances in October. November, 2 tests.
Thank you.
Mr. Brown, you're not muted. 2 tests positive for those substances in November for THC, I should say, 1 for cocaine, another with an abnormal creatinine level. Continued positive tests for THC, and most recently on February 24th, he had a positive test for THC and cocaine. And then on March the 8th, he missed his sample. In this case, the court had previously cautioned the defendant about testing positive and had warned him a positive that he was not to be using cocaine. That admonishment happened on February the 3rd. He has been adjourning this case for several months. So at this point, I am requesting that the court revoke his bond and remand him to the custody of the Washtenaw County Jail pending any further hearing.
Your Honor, may I speak?
Ms. Anderson?
Thank you, Your Honor. Your Honor, unfortunately, I've not had a chance to make any contact with any substantive contact anyway with Mr. Thorns. I am in receipt of the bond violation report. It does indicate that there was a relapse and that he was to get back in contact with CCOP. I don't have any further information as to whether he's made that contact since the date of this report.
Your client wanted to talk. I don't know what you...
I would advise Mr. Thorns not to address the specifics of the violations.
Okay, yes.
If there's something else that you wish to address, Mr. Thorns, then we can move forward from there.
No, yes, I was released from prison in October of 2021. I've been out of jail since then. I haven't had any police contact. Yes, I did have a relapse. I'm not running from the state. I have a whole nother case that I'm dealing with that I'm on bond for. And the reason I wasn't able to get back with Brad was because the violation had came as in it was before it was after I got the message from Brad. I have class today. It's not like I'm running from the state or anything like that. I'm dealing with it in my own way. I have a lot going on. I'm just trying to get my life together, period. It's nothing. I'm not running from the state at all, period. I just had court the other day. And for this case, I'm trying to come, I really want to waive my preliminary examination and try to find a global resolution because I'm going to have Darlene O'Brien.
All right, look. Grand reality, you don't stop using, you're going to end up going back to prison. That's grand reality. What I'm going to do in this case is his probable cause, I'll adjourn it out 1 week to the 17th, 9 a.m. I will indicate, sir, that I am revoking your bond. I did admonish you to continue to use. The only thing that I would add, which makes it worse for you, is that when the cocaine disappeared, at least as a positive test, you had abnormal creatinine, which this court considers to be a positive. So you've been using a whole lot more when the cocaine shows up. So you need to report to the Washtenaw County Jail by 6 p.m. this evening. If you fail to report, a bench warrant will issue for your arrest. And
So I need to go report today?
You need to report to the Washtenaw County Jail by 6 p.m. today.
Okay.
If you fail to report, so that you know, I'll issue a bench warrant for your arrest with no bond. And you can bank on it that I'm going to come get you.
Good morning, Your Honor. Regina Garrett-Caraher on behalf of Mr. Black, who's appearing via Zoom. Cody, can you state your name for the record?
Cody Black.
Your Honor, my defense counsel and I approach before we proceed any further.
Really? Okay.
I'm sorry.
Can you put all of us into a bench conference, please?
Okay.
Court calls the case of the people versus Raquel Castellet.
If we have to do a 2-week adjournment, and I hate to do this but could we have a brief breakout room with Your Honor and counsel?
Your Honor, I swear this is my
I gotta
last
look,
case.
I've got to start looking more angry because everybody wants to talk to me. Fine.
This is my
let's-
last case for today, though.
Yeah, you've been in like 8 of the breakout rooms I've had. I get it. Okay.
No, I'm sorry.
Let's.
I'll take the
Yeah.
blame for this one, Your Honor. It's on me.
Okay. All right, this is Tana's fault. Can you put us into a breakout room, please? Thank you.
Thank you.
Okay, we're back on the record in the Castello matter. What the court will do, having a little bit more information, I will adjourn it out just 1 week. I'll adjourn it to the 17th at 9 a.m. And defendant's bond will continue. All
Thank
right,
you,
Ms.
Your Honor.
Castello? And Ms. Castello, you
Yes,
don't
sir.
have to look so worried. You don't have to look so worried. We weren't saying really bad things about you. Okay?
No, Markel,
She's like-
everything's good.
She's
I will
like-
call you.
She's like,
I'm like, oh
long
no.
time. All right.
You're good. I will call
Thank
you.
you
I
guys.
promise.
Your Honor, you have a wonderful day.
You do the same, man.
Thank you, Your
Thank
Honor.
you.
That's my last
Thank-
case for the day.
All right. Thank
Have
you.
a great one. Thank you, Miss Tana.
Court calls case, the people versus Marcus Pollard. All right. What are we doing on this?
I have spoken with Mr. Pollard and we wish to waive the preliminary exam.
Before he waives, Mr. Pollard is likely going to need to turn himself in. You've seen the bond violation.
Yes, Your Honor.
I had issued a bench warrant with no bond because of what was contained in that report.
This is the report from February 10th.
Report from, yes, from February 10th.
Was there a warrant issued after the 7th of February?
The warrant I issued was on February 16th.
Okay, I did not know that.
So when is he going to turn himself into the jail?
Mr. Pollard, you need to turn yourself in on these bond violations. When will you be able to do that?
Well, I'm going to tell him, and I'm going to try to make it as convenient as possible, but
Okay.
So how did I violate the bond? Hello?
yeah, we're here.
How did I violate the bond?
We had talked briefly about it. Oh, go ahead, Your Honor.
Defendant failed to report for intake testing. Telephone to defendant, left a voicemail. Telephone the community corrections back on January 27th, stating that he did not know he was required to report. He was then at that time instructed to report on January 28th to submit to testing and return on January 31st for intake paperwork. Telephone the front desk on 1/28/22, stated he started a job and could not report to test. Formed the front
Right.
desk to report for intake and testing on the 31st. On the 31st, you then failed to report and did not
did-
contact community corrections. On 2/1, they sent a bond report on. You failed to appear then in court on February 3rd, and a warrant was issued. The warrant somehow or another got canceled. Telephoned the front desk on 2/8 at approximately 4:20, was scheduled for intake on 2/9. And once again, you did not appear and did not contact community corrections. As of the writing, you have not completed intake or submitted to testing as was ordered. And that was on February 16th or on February 10th. On February 16th, after receiving the report, the court issued a warrant. You still have not gone over, and I am almost a month out. Anything else you want to know?
No, I was dealing with CMH. I've been dealing with CMH, and I really didn't know because it's my first time ever having to own bond anything, and I didn't really know the procedures. So when I did go up there, it
Well,
was
I'm
close.
explaining to you the procedures right now. And that is you need to report to the Washtenaw County Jail, otherwise we will come and get you. Which would you prefer?
I'll report. All right. Okay, I'll report to you.
Here's what I will do. I will adjourn this out 1 week. Probable cause conference will be adjourned to March 17th, 2022, 9 a.m. I am going to order that the defendant is to report
Good.
to
Community-
the Washington
correct?
County Jail. You are to, no, you need to report to the Washington County Jail. You are to report to the Washington County Jail by 6 p.m. today.
Okay. Gotcha.
Failure to report, sir, so that you understand how I work. I will make sure the Washington County Sheriff's Department comes out and gets you. And then there's not gonna be a whole lot of hope in terms of getting any bond from me if you don't follow my instructions. Understood?
Good.
Thank you.
Yep.
Court calls the case, People versus Robin Robinson.
Rob Dowden, for the people.
Sandra White on behalf of Robin Robinson.
Hi, Robin Robinson here.
You want to
Your Honor.
argue? You want to argue with me too? No, I'm kidding.
Uh-uh.
I just usually after something like that, nobody wants to talk to me. All right.
Your Honor, there is a
Court calls the case of the People versus Toya Adlerman. You have her bond violation report.
I do not think I do. Let me take a look.
I got a violation.
Oh, yeah, you do.
For what?
No, I don't believe I do get the bond violation.
All right, here we go. Ms. Adlerman was scheduled to report on February 4th for intake. She did not complete intake until February 7th. Due to being ill and unable to report in person, she was instructed to begin calling the DART hotline and report for weekly testing. She submitted an initial test on 2/10/22, which was positive for marijuana or THC. We didn't have a card. Her second test was also positive, excuse me. Zeller was approved by the court to begin testing at onsite in Redford. She was advised to sign a release and have all tests sent to community corrections via fax or mail. And as of this date, she has not, the date of the report, which was 2 days ago, they have not received any tests, which means they have not received test results for 3 tests in a row.
That's a lie. That's a lie. Can I speak?
Okay, you want me to call the community corrections officer and say that they're lying in a report to the court?
No, I got Ms. Wild's text messaging who said that she did receive the test results from on site. I have a text message for that. I could screenshot it and email it to my attorney.
When did you receive that text message?
Right now. I got the text message from, scroll down here. Boom. This was, all right. Text message March the 1st. Text message Friday.
Is that text message indicating that they received the results from Redford?
Yes, she said she did. Yes, she did. She said she received the results and my little signature of admittance for the THC. And my magistrate, Alicia, already in my arraignment said that I could use my medical marijuana because when I went to jail, I had my medical marijuana
You have
card
to,
with me.
you have to
I had the card
have
with
the
me.
card, ma'am. You have to give the card to community corrections.
I did. I gave it to
Not
Ms.
so-
Wiles the day that I
Okay.
signed up for it. She took a copy of it. Ms. Wiles has a copy of my medical marijuana card that I've
Okay,
had for 6
I'm
years.
not, ma'am, did you listen to what I read? I am not so much concerned about the marijuana.
Mhm.
I don't
And I've
see
reported-
that they didn't violate you for that. I don't have test results.
I've given at least three results. There was 2 at community corrections 2 with Ms. Wild that I did there, and I did 1 at the on-site. And the only reason
Counsel,
why
what did you
the
want to
time-
do with this? Because I'm not going to sit up here and argue with this defendant.
Okay.
What do you want to do with this?
Right. Well, I was unaware of the bond violation before, like I'd said, so I didn't have a chance to speak with her, but it sounds like she does have some proof possibly. If we could maybe just keep the prelim date, and if she can get that over to me, I can get it to the court.
I need to get what to you?
The text messages that you say that you have from Miss Wild, if you can
Yep.
give me screenshots.
Here's
of
what
those.
I'm going to do. You need to get that over there, get all of that corrected with community corrections. I'm not setting it for prelim at this point in time because otherwise I'd be taking other action prior to setting that. I'll adjourn it out 1 week to the 17th. She needs to have all of that corrected and get all of that information if she's saying this report is wrong.
Also, can you,
Bond will continue.
I have one more thing though, for the testing. Can you re-enter that I am allowed to use my medical marijuana? Because Magistrate Fink,
If
when I went to
they have
arraignment,
it,
she approved it already.
Ma'am, you have told me they have it. So I'm not re-entering anything. If you have a medical marijuana card, you would be permitted to use.
Ms. Wild said that that she didn't get it on record from the judge, from Mrs. Fink, when I did the magistrate. So she
I thought you
to
said
address-
that Miss Fink, I thought you said Magistrate Fink said so.
She did, but they didn't see it in like the
I'm
court,
not,
like
ma'am,
recordings.
ma'am,
Yes.
I am not doing anything. I've set you for next week. Everybody needs to get everything clear. You need to get that information to your attorney.
Okay,
Thank you.
thank you.
Court calls the case. People versus Alexis Baker.
Baker. Ms. Baker, will you please unmute yourself and state your full name for the record, please?
Alexis Baker.
You want to argue with me too, Miss Baker?
No.
Oh, okay. I'm just checking. All right. I'm just trying to figure out what I'm in for. Miss Baker goes, oh my God, no.
No arguing.
Okay.
Court calls the case. People versus James Blake.
Jessica Blanche appearing on behalf of people.
Good afternoon, Your Honor. Chinazi Kiriakin-Ruli on behalf of Mr. James Blake.
Oh boy, talk about somebody that wants to argue with me. Where's
Yeah, I've
Mr.
been practicing. I've been practicing.
Not you.
Bring you
Not
up.
you. I'm not talking about you, but now if you want to go, let's go. I'm about ready today.
You all
so-
warmed up now.
Yeah. I stay warmed up. All right. What are we doing on this case?
Your Honor, I have had an opportunity to speak with my client. We will be requesting an adjournment. For the record, there is an offer from the people. Wait, is there an offer? We are in communication about a possible resolution to this case. At this time, we are requesting an adjournment to send over some documentation to the people. If we could get 2 weeks, Your Honor, that would be greatly appreciated.
Any objection from the people?
No, Your Honor.
Probable cause will be adjourned March 24th, 2022, 9 a.m. Bond will continue.
Thank you so much, Your Honor.
Next time Blake comes back, I'll be ready for him.
All right, warm him up. All right, thank you.
All right, thank you.
Yep.
Court calls the case. People versus Wyatt Boyce.
Good afternoon, Your Honor. We're arguably ready in this matter, but we
Oh,
ain't arguing with nobody.
oh boy. My day's
Special
going
Monday
like
for the
it
people,
is,
Your Honor.
and then Lauren Brown shows.
And then Lauren
All right.
Brown showed up.
All right, I do have a bond violation report.
Yes, Your Honor.
Well, that's news to me.
Is he here, Mr. Boyce?
Yes, he's here. Mr. Boyce, could you
do you
Wyatt Boyce.
do you have a medical marijuana card?
I do not. I was using marijuana before I was arrested.
All right, it's expired and he's he's testing positive and doesn't have a card.
And Your Honor, my notes from Community Corrections indicate that he was ordered to report on January 30th, 2022, within 24 hours. He actually completed intake on February the 7th. And the February 7th 10 panel had the positive THC, and we continued to have positive THC all the way to March the 2nd.
Okay, so my first question is the bond, was Mr. Boyce aware that there's a bond condition saying that he should not use marijuana? It's not illegal anymore. So on the face of it, that's not an issue. Only if it's a violation of the bond itself.
Right. If it's a violation of the bond, and I believe, yeah, because it's a DV, so I'm sure she had the standard conditions. And that is correct. He was not to use. It's on his release.
Okay. So the second question becomes, how long after he was arrested was he tested?
Well,
he didn't report for a week.
Then he was tested on the 7th. Okay. And at least for the next 30 days, well, about 30 days, he's been positive.
All right.
And they had a discussion about, so that you know, Mr. Brown, because I know you don't have it. He did indicate that he had an expired card, but he doesn't. I mean,
and Your Honor, at this point, the people would just be requesting that he continue testing, and I'd request levels for the next few tests, and then we'll sort of go from there.
Yeah, no, that's fair. If Mr. Boyce could be told by the court that we've already been told that, but if he reminded not to use marijuana during the pendency of this case, as that is condition of his bond, I believe that he can follow that.
You understand that, sir? Because he told me, well, he told Community Corrections he hadn't smoked since intake.
Correct.
So whatever he had before intake was just some good stuff. I'm just saying, I don't know. I don't do it. So
allegedly,
allegedly it must have been good. I don't know. It's hanging around. Didn't want to go home.
I was smoking pretty heavily beforehand.
Okay. All right.
So I just want levels, Your Honor, and for him to continue testing.
All right. I'll indicate defendant to continue testing. Now, what we're going to do with the case?
Oh, yeah, we're setting this. Yes, we're setting it for preliminary examination. Now, they say marijuana use makes your memory kind of funny.
You didn't even know my name this morning. So. I don't know what that's about. I'm just saying. All right. So, you want a preliminary examination? Will it be by Zoom or in person?
Yeah. Yes, please, Your Honor. By Zoom.
By Zoom?
Yes, please.
You gonna remember that? No, I'm just saying. Okay. Preliminary examination.
Do my best. I'm gonna write it down.
Yeah. Okay. You do that. Preliminary examination will be by Zoom, and I guess so we can get. Yeah, this is. March 22nd.
Do we possibly have the 29th, please, Your Honor?
As long as Mr. Boyce has no issue with that, he's out of custody. I don't see that as an issue. Is that an issue for you?
What about 4 or 5?
Yes, please.
Will that work for you, Mr. Brown?
It always works for me. Mr. Boyce, do you have anything scheduled at that time that will prevent you from participating?
No, I do not. And if anything comes up, this is more important than anything else. So that works for me.
All right, then.
I like the way he thinks. 4-5, April 5th, 2022. That will be at 9 a.m. And that will be before Judge Perry.
All right. Thank you.
All right.
Thank you.
Bond will continue. You are to continue testing. We're going to get levels on that. Okay.
Okay. Thank you.
All right.
Thank you.
Thank you. Let's see if Mr. Brown can remember that date. Court
wrote it down. I just have to remember where I wrote it down, though.
Down, right. Court calls case, People versus Colleen Byers.
Jessica Blanche appearing on behalf of People.
Ready, Judge. Torshell Feaster, Assistant Public Defender on behalf of Mr. Byers. Mr. Byers, please state your name for the record.
Byers.
Thank you, Judge. I've had a chance to talk to Ms. Blanche on this matter, as well as
I
Mr.
think
Byers.
there's a bond violation on Feaster.
Me?
Oh, go ahead. I'm sorry. Go ahead. Never mind.
I try to keep my nose clean, Judge.
Yeah, I know. Not doing a very good job. Go ahead.
Scared me for a minute. Mr. Byers needs a brief adjournment, Your Honor, so that we can try to get a resolution worked out on their file, Judge. If we could go 2 weeks, that would be very helpful.
Probable cause will be adjourned March 24th, 2022, 9 a.m. Bond will continue. That tells you Feaster's doing stuff he's not supposed to be.
Am I free to leave, Judge?
Yes, you are free to leave. Thank you. That was the 11 o'clock block. All right, folks, give us about 5 minutes and then we'll come back. We'll start with the next block and we'll just try to keep moving. I got to get that set up. All right, court is standing brief recess.
Oh, Your Honor, I just need a breakout room with Mr. Kyle unless you need a breakout.
Oh,
room.
Mr. Kyle. Oh.
Yes, it's just so I can get his contact.
Good.
info.
Oh, good. I don't have to talk to you. All right.
No,
So no,
not-
I didn't mean it that way. That sounded much worse than I meant it.
Not anymore today, anyway, hopefully.
Okay. So if we can put counsel and Mr. Kyle into a breakout room.
Thank you so much, Your Honor.
Thank you. Thank you, ma'am. Court calls the case, People State of Michigan versus Tony Darnell Smith. Well, the good news is, Mr. Feaster, I canceled your warrant.
I appreciate that.
Yeah, I do what I can.
Yes, yes.
Mr. Smith is not here.
No, Your Honor. But I don't know why he's not here, Your Honor.
Bench warrant will issue for defendant's failure to appear. Bond is set amount of 10,000. I'll give a 10% privilege on that. That warrant will issue immediately.
Thank you, Judge. Thank you for canceling my warrant.
Yes, sir. And giving your client one. All right. LaShawn Taylor.
Rob Dodd on behalf of the people. As you notice, Mr. Feaster kept moving around. He keeps going.
I know.
He's worried about getting arrested.
A little shady.
Defender Kalina Anderson with on behalf of Mr. Thorns. Mr. Thorns, please state your name.
Patrick Thorns.
Your Honor, today's the date and time for probable cause conference. I am in receipt of a bond violation in this case. And I know the court is aware, but for the record, the defendant was first placed on conditions in October 2021. He tested positive for THC, cocaine, and amphetamines. 2 tests positive for all 3 of those substances in October. November, 2 tests.
Thank you.
Mr. Brown, you're not muted. 2 tests positive for those substances in November for THC, I should say, 1 for cocaine, another with an abnormal creatinine level. Continued positive tests for THC, and most recently on February 24th, he had a positive test for THC and cocaine. And then on March the 8th, he missed his sample. In this case, the court had previously cautioned the defendant about testing positive and had warned him a positive that he was not to be using cocaine. That admonishment happened on February the 3rd. He has been adjourning this case for several months. So at this point, I am requesting that the court revoke his bond and remand him to the custody of the Washtenaw County Jail pending any further hearing.
Your Honor, may I speak?
Ms. Anderson?
Thank you, Your Honor. Your Honor, unfortunately, I've not had a chance to make any contact with any substantive contact anyway with Mr. Thorns. I am in receipt of the bond violation report. It does indicate that there was a relapse and that he was to get back in contact with CCOP. I don't have any further information as to whether he's made that contact since the date of this report.
Your client wanted to talk. I don't know what you.
I would advise Mr. Thorns not to address the specifics of the violations.
Okay, yes.
If there's something else that you wish to address, Mr. Thorns, then we can move forward from there.
No, yes, I was released from prison in October of 2021. I've been out of jail since then. I haven't had any police contact. Yes, I did have a relapse. I'm not running from the state. I have a whole nother case that I'm dealing with that I'm on bond for. And the reason I wasn't able to get back with Brad was because the violation had came as in it was before I asked, it was after I got the message from Brad. I have class today. It's not like I'm running from the state or anything like that. I'm dealing with it in my own way. I have a lot going on. I'm just trying to get my life together, period. It's nothing. I'm not running from the state at all, period. I just had court the other day. And for this case, I'm trying to come, I really want to waive my preliminary examination and try to find a global resolution because I'm going to have Darlene O'Brien.
All right, look. Grand reality, you don't stop using, you're going to end up going back to prison. That's grand reality. What I'm going to do in this case is his probable cause, I'll adjourn it out 1 week to the 17th, 9 a.m. I will indicate, sir, that I am revoking your bond. I did admonish you. You continue to use. The only thing that I would add, which makes it worse for you, is that when the cocaine disappeared, at least as a positive test, you had abnormal creatinine, which this court considers to be a positive. So you've been using a whole lot more when the cocaine shows up. So you need to report to the Washington County Jail by 6 p.m. this evening. If you fail to report, a bench warrant will issue for your arrest. And
So I need to go report today?
You need to report to the Washington County Jail by 6 p.m. today.
Okay.
If you fail to report, so that you know, I'll issue a bench warrant for your arrest with no bond, and you can bank on it that I'm going to come get you.
Okay, yes, sir. No problem. I'm going to report.
Right. And then I set it for next week. Thank you.
This case demonstrates a lesson that appears repeatedly in criminal courts. Bond conditions are not suggestions. Once a defendant is released on bond, compliance with court-ordered requirements becomes essential. Missing appointments, failing to complete testing, or ignoring reporting requirements can quickly lead to warrants, bond revocation, and jail time. The judge's reasoning throughout these hearings was straightforward. The court was not focused on excuses or misunderstandings. It was focused on whether defendants followed the specific conditions they had agreed to. When violations were documented, the judge repeatedly emphasized accountability and compliance rather than personal explanations. Although this case was not a classic sovereign citizen matter, it highlights a similar principle often seen in those cases. Many people believe they can argue around legal obligations through technicalities, personal interpretations, or unsupported claims. In reality, courts rely on evidence, documented compliance, and established legal procedures. Assertions alone rarely overcome official records. One of the most significant moments occurred when a defendant challenged the accuracy of a court report. Rather than accepting the claim at face value, the judge required proof and directed the parties to verify the facts through proper channels. That response reflects a core principle of the legal system. Evidence matters more than opinion. The takeaway is simple. Whether dealing with bond conditions, testing requirements, or court appearances, compliance and documentation carry far more weight than explanations after the fact. In court, credibility is built through actions, not arguments.